Thank you for taking the time out of your day today and choosing to listen to my webinar. Today's topic is Am I de facto? My name is Belinda Jeffrey. I'm an associate at Michael Lynch Family Lawyers. I have been practicing in the area of family law now for 12 years, and hopefully I can enlighten you a little bit further today. A little bit about our firm. We are specialists in family law. We have 8 lawyers available, all who have a required number of years of experience and practice. We have accredited specialists as well as solicitors who have been practicing for a significant number of years, so we can confidently advise you and your clients. Today's agenda is to talk about Am I de facto? And we'll be talking about the type of relationship, the applicable law, meaning of de facto, threshold for de facto, separation, time limits. I'll give you some case examples which may or may not scare you, and I'll also talk to you about some cautionary notes, what would happen next if a de facto relationship was found, and also some tips and traps from my view anyway. To start, not knowing what your knowledge was in this area, I thought it was helpful to clarify when I say Act, what it is that I'm referring to. So I'm referring to the Family Law Act of 1975, which is a federal piece of legislation accepted by Australian territories and all states except for Western Australia. Western Australia hasn't given federal power. When I talk about sections, there's sections of the Act, and the particular sections relevant for de facto relationships are Section 4AA, which is the definition, as well as Part 8AB. The courts that have jurisdiction in the legislation of Family Law Act are the Family Court and the Federal Circuit Court, also previously known as the Federal Magistrates Court. So if you have clients that have previously been through court proceedings, they may talk about a Federal Magistrates Court. Type of relationship. So we're here to discuss today, am I a de facto? De facto versus married. Married is simple in terms of identifying because you've gone through a marriage ceremony and therefore you know if you are married or not. Whereas de facto has that added complications, especially now as our relationships take a different turn than what they have traditionally in years gone past. In November 2008, the Family Law Amendment, De Facto Financial Measures and Other Measures Act was given royal assent. This was one of the most significant changes being legislated for, as it included de facto property rights under the Family Law Act, and it came into force on the 1st of March 2009. We're now celebrating the 10th anniversary of that piece of legislation. The primary objective for the amendments to the Family Law Act was to extend the financial settlement regimes to parties in a de facto relationship, whether they are hetero or same-sex. Those parties could now seek discretionary relief, maintenance and property adjustment orders where they previously couldn't under the Family Law Act. Prior to this piece of legislation, only certain de facto relationships had some rights under state-based legislation, and in particular in Queensland it was under Part 19 of the Property Law Act 1974. Therefore, since the 1st of March 2009 and the 1st of July 2010 for couples who live in South Australia, they have been able to access the regime under the Family Court and the Federal Circuit Court to seek property and maintenance from another party. At first glance, most would say that the rights of de facto couples compared to that of married couples, that there's little differences, but there are a few and they're key. Date of separation is quite relevant when it comes to being in a de facto relationship and when you do separate, because you have to have had the relationship or separated after 1 March 2009 or 1 July 2010 in South Australia to be able to use the Family Law Act as the vehicle for seeking those property and maintenance rights. when you do separate, the date of separation is important, as you also then have a time limitation, which you would not then have if you were married until you were divorced. The financial causes which the family law courts can deal with are slightly different for de facto. And also there's the consideration of when you're in a de facto. So the length of the relationship and other qualifying factors, the geographic preconditions, interim or procedural orders and injunctions that you could seek when you're in a de facto versus a married couple, and also in relation to financial agreements. Meaning of a de facto relationship, what is it? So Section 4, subsection 1 of the Family Law Act defines de facto relationship as having the meaning set out in Section 4AA, subsection 1 of the Act. It says a de facto relationship is defined as a person is in a de facto relationship with another person if the persons are not legally married to each other and the persons are not related by family, and having regard to all of the circumstances of the relationship, they have a relationship as a couple living together on a genuine domestic basis. Having regard to that definition, it does mean that a de facto relationship can also be recognised when one of the persons is in the relationship is also legally married to another, or in fact in another de facto relationship. So we can have the situation where there are multiple relationships existing at the same time, and then separation of multiple relationships. Genuine domestic basis, the court needs to look at and consider what makes up genuine domestic basis. So some of the factors that they look at are the duration of the relationship, the nature and extent of their common residence, whether a sexual relationship existed, the degree of financial dependence or interdependence, and any arrangements for financial support between them, the ownership, use, and acquisition of their property, the degree of mutual commitment to a shared life, the care and support of a child or children, and the reputation and public aspects of their relationship. I want to take the time to talk through those elements and what they may or may mean. And I appreciate that there's probably some general knowledge out there about what some of these may mean. The duration of the relationship. The legislation requires a 2-year minimum, subject to exceptions. Some people come unstuck in that they think if it is less than 2 years, well, there definitely cannot be a claim to be in a de facto relationship. There are some exemptions to that and exceptions, and that's when you look at other factors such as a child or significant contributions. It also doesn't mean that if the relationship is longer, so more than 2 years, it's not determinative or necessarily any better assistance in determining whether there's a de facto relationship. So just for the fact that you may assert, or your client might assert, that the relationship was in fact 10 years doesn't absolutely guarantee that it will be considered a de facto relationship. The nature and extent of their common residence. Parties do not have to live together on a full-time basis, nor do they have to live together for the entirety of their relationship. Having more time together does not exclude the possibility of a de facto relationship. The quality and nature of the common residence is important rather than the quantity of time. How much time they do spend together is relevant, and reasons why they don't live together on a full-time basis can also be relevant, and that might be it's out of their control for work reasons or similar. What is the nature of their common residence? If there's one property, or are they moving between each other's principals' homes? Do they rent a common residence separately or together? Have they changed common residences together? Have they bought and sold property? What address does each give for receiving correspondence to schools, doctors, employment, Centrelink, and what have you? Whether a sexual relationship exists is also not a determinative factor. Just the mere fact that there was an intimacy in the relationship doesn't mean that there must have been a de facto relationship. It also doesn't mean if it's exclusive that there must have been a de facto relationship, and the frequency doesn't affect whether it's a de facto relationship. The degree of financial dependence or interdependence. Some of the factors that the courts looked at are, do the parties have joint bank accounts? How did the parties meet their expenses? Were there loans? Were there utility bills that they shared? How were the general living expenses shared? Did one party support the other financially? And if so, to what extent? Did one party perform unpaid work or household duties for the other party? The ownership, use, and acquisition of a property. Did the parties acquire property during the relationship? And if so, who acquired it? How was it paid for? How was it owned? How did they use it? How significant was the property? Did the parties allow each other to use their respective property? There have also been cases where parties have applied for a rental property and may have been denied that, but that can be used as evidence to show that there was an idea or an intention to own or acquire a property. Similarly, with putting down names on mortgage applications or loan applications, or going and looking at properties. The degree of mutual commitment to a shared life. Did they live together in one home? Did they spend regular time together? If so, how much? What conversations and statements did they make to each other about their commitment, whether that was verbal or in writing? What representations did they make to others about their commitment? Family, friends, government agencies? Did they have projects together, renovations or work or voluntary work together? Were they involved in each other's family lives? Did they attend functions together? How did they hold themselves out at functions? If they gave gifts to each other or to others, were they significant? How were they given? How were they signed? How were they engraved? All these are relevant when looking at that degree of mutual commitment. Whether the relationship is or was registered under a prescribed law, this is something that's becoming a little bit more common, and people get themselves a little bit caught by this because migration agents are certainly encouraging parties when there is someone applying for a visa or needing a visa to start that relationship or come to the country. They say, well, register your relationship with the state or register your relationship with an agency. This, in a way, adds to the element to say, well, we are a de facto relationship. Again, it's not completely determinative, but it does assist in the courts determining that there is a de facto relationship if you have signed such a statement, because usually you'll then have to follow through with opening up joint bank accounts and you'll be attesting to statements to other agencies. The care and support of a child or children, that's fairly obvious in that if they have a child together, the courts usually find, although not always, that there has been a de facto relationship. There have been cases where parties have tried for fertility treatments, and the court has seen that as in an effort of having a care or existence of a child. There's also been foster children. Pets are something that's been a little bit of a issue that have arisen in cases because some people very much see their pets as children. There has been suggestions whether that the care of a pet and the mutual acquisition of a pet might expand to say that it's the care and support of a child. As yet, no case has turned on that exact fact, but it's been certainly looked at. The public aspects of the relationship, we did somewhat touch upon that when we looked at the reputation and the mutual commitment. But again, the court would look at, did the parties socialise together? Were they known as a couple? And if not, why not? In what circles were they known as a couple? So family, extended family, friends and work. Did they attend important functions for each party? So were they invited to other family functions? Did they make provisions for each other in wills or health directives, in trusts, in superannuation beneficiaries? Were they emergency contacts for each other, passports, airport immigrations, hospital admissions? Were they next of kin? Were they emergency contact for the other party's child with a school or with a doctor? It's quite clear from that none of these factors are going to be on their own determinative. So none of them have to all exist at once. All the factors could be there, they may not be there. There could be one of the factors. They just have to be taken into account, and that's what Section 4AA suggests to the court. And when looking at that, the court says that there are gateway requirements. So the gateway requirements to determining the de facto relationship are that duration, So the parties have been in a de facto relationship for at least 2 years. Now, that can be an aggregated period of time. So it could be separated by periods of separation. It could be over a course of a number of years. It could also fall in that you might have been married and then separated and then into a de facto relationship as well. If there's a child of the relationship, then the court's going to find that most times that there is a de facto relationship. If there's been a significant, substantial contribution, and that might be something in the area of financial or non-financial, and also whether it was registered with a state or territory. So the court's going to look to those gateway requirements, but also have regard to those additional factors that we spoke about. The next slide is really just a bit of a short slide, a bit of a break, a bit of a snapshot of when you are in a de facto relationship. So it has to have broken down after the 1st of March 2009 if you're living in all other states and territories except for Western Australia and South Australia. It'll be the 1st of July 2010 if you're in South Australia. For Western Australia, they haven't given the federal power, so they have their own Family Law Act and own requirements under there. And you should meet one of the 4 gateway requirements, so those gateway requirements that I spoke about on that previous slide. Often a question we're asked about is what is separation and whether they are in fact separated, whether they be in a de facto relationship or not. A communicated intention to separate is the definition. So the communication can be by way of text message, it could be by way of email, it could be a face-to-face conversation. I have seen a case where it was written on a post-it note and left on the fridge. It's just a communicated intention. The other party need not necessarily accept it, and they might deny that they wish to separate, but as long as one party can show that they put that intention out there, it'll be said that they're separated. You also don't have to be physically separated. So some people have had the misconception that you need to not live together. You can be separated but living under the same roof. For de facto relationships, there is a strict time limitation. So knowing that date of separation, whether you dispute it or not, so whether you're the party saying, well, no, I say we weren't separated, you still need to tell your lawyer or be aware of that date of separation, as there is a time limitation. Applications for property settlement and spouse maintenance claims need to be made within 2 years of the date of separation or the end of the relationship. So you always need to err on the side of caution. If you dispute that date of separation, you might still say your date of separation, but make sure it's within 2 years of the other person's date of separation so that there can be no suggestion that you've missed that time limitation. If you miss that time limit, there are exemptions as to why the court would still address it, but it's never our advice to hope that you can meet with one of the exemptions. The exemptions to the 2-year limitation is hardship would be caused to a party or a child if leave weren't granted, or for a maintenance application, the party's circumstances were such that if she were not able to bring the application and she was supporting him or herself with an income tested benefit, that the court needs to grant that leave. But again, it's better to act cautiously and file before that. If you miss that time limit and you also are unsuccessful with the leave application that you would have to bring to say, let me proceed even though I'm outside the 2-year time frame, the court may not grant it. And if you owned any jointly owned property or jointly owned assets, you may then have to bring it through the state courts under laws of equity as opposed to under the family court, which considers the elements under the Family Law Act. I've set out in the next slide just a little bit of a short about obtaining leave and how that goes through, and the risks of doing so as well. There is always risks of costs if parties don't do things within a timely manner. This is probably a good opportunity to talk about some cases and to think about what courts have decided when they've been asked to determine matters. The first case I wanted to discuss, and I have the citations up on my slide, is Regan and Walsh. Now, this is a 2014 case. And in this situation, the parties acknowledged that they had a shared residence on various occasions, and that those various occasions totaled more than 6 years between the period 2005 to 2013. There was also periods when they weren't living together, which was due mostly to employment reasons. The parties disagreed as to the nature of their relationship. So they weren't disagreeing on that they shared a residence, that it was over that 2-year period, but they disagreed on the nature. So that genuine domestic basis and the nature of their relationship, which we discussed before. So Mr. Regan, who was the applicant, he asserted that they were in a de facto relationship, but Mr. Walsh said, no, we weren't in a de facto relationship, and rather described their relationship as friends with benefits. He said, despite them living together at different periods for a period of 6 years, that they didn't own any property together. They didn't acquire any property together. They didn't have a mutual commitment to a shared life. They didn't put out an outward perception of their relationship. And there was no evidence that the applicant could point to that disproved what Mr. Walsh was saying. On that basis, the court determined, despite the parties agreeing that they lived together, and despite the parties agreeing that they had an intimate relationship which existed between each other, it wasn't enough to find that the relationship was a de facto without the presence of those other factors. So they had 2 of the factors, including one of the gateway factors, but the court still determined, because the other factors weren't there, that they did not have enough to satisfy that there was a de facto relationship. What I thought we might do, now that I've done one case and spoken through one case, is talk about the next case of Newland and Rankin, which is a 2017 Federal Circuit Court of Australia decision, and give you some factors in that case, and then have you be the judge as to what the question is that the court had to determine. So there will be a poll that will come up that I need you to select yes or no. I'll give you some time to do that, and I'll move on to another case while you can consider that, and then we'll come back and look at the poll results. So this particular matter, Newland and Rankin, was determined by the Federal Circuit Court of Australia. The issue was whether or not a casual relationship over a 5-year period was a de facto relationship. So the facts are, and these were the agreed facts, the parties began an intimate relationship in April 2003. They lived together sporadically until 2008. The one party to that relationship was only living sporadically with the other party because they were married. And they were living in that, they were still married to their wife and having this relationship with the other person. And that's why they could only live sporadically. And they say, well, it was only a casual relationship because they were married, and they couldn't therefore commit and make that greater mutual commitment. The other party, however, said that there had been efforts to commit, and they pointed to that the other party had fallen pregnant. They'd had the discussion about whether to keep that baby. Ultimately, they determined to terminate the baby. They also looked at the shared residence that they had. They looked at the whether there was an outward communication of their relationship, and there was cards produced as well as emails produced, and they considered all those factors. Knowing those facts, I would like for you to tell me whether you think the court would find that this was a de facto relationship or whether they would find that this was a casual relationship. I'll move on while you're doing that poll to another case. It's a little bit similar in facts. This one's called Sham and Shay, and the citation will come up once we've done the poll. You'll see the citation there. So Ms. Sham and Mr. Shay met in 2011 when Ms. Sham was working at a massage parlour. Mr. Shay had been married since 1997, and for most of his relationship with Ms. Sham, he was still living with his wife. With regard to the public aspects of their relationship, the parties had a social life whereby they frequently visited restaurants, beaches, and shopping centres. While they were occasionally accompanied by Ms. Sham's daughter, there was no involvement of other people in these activities. Ms. Sham had only limited contact with members of Mr. Shay's family. The court held that despite this, there were other public aspects to the relationship. This included numerous documents addressed to Mr. Shay at Ms. Sham's house, electricity accounts which had come to him in their joint names to that home, and that they'd also conceived a child through IVF. The court was satisfied in those circumstances that there was a de facto relationship, saying it was only for 18 months, but because of that child and because of the public aspects, they found a de facto relationship. So I'm just looking at the polling results now, and thank you to those that participated. I realise we don't always like to put it out there what we think. So the results show that everyone said yes, that there was a de facto relationship. So in this particular case, you might be surprised to learn that the court determined there wasn't a de facto relationship. So whilst the court said the existence of a sexual relationship can be an important factor in determining the existence, the other factors were given a greater weight. So the fact that they didn't have a mutual commitment to a shared life, despite the terminating of the pregnancy, despite the fact that the court couldn't be satisfied that there was enough of a public perception of a relationship, and despite the fact that there was no intermingling of funds towards a mutual commitment of life, they found that there was no de facto relationship and it was instead a casual relationship. The next case that I thought we'd talk about is T and Mur. The applicant in this case was 37 years of age, and the respondent at the time of trial was 86 years of age. The respondent's case was run by his case guardian, as the respondent suffered from dementia. The applicant lived in the respondent's home. There was very little other evidence to support the existence of a de facto relationship. The court was asked to consider by the applicant whether there was a de facto relationship. What some of the evidence was that the applicant relied upon was tasks that the applicant undertook for the respondent in terms of care. So the applicant in this situation said, well, I provided services and I believed we were in a de facto relationship because I was providing those services and wasn't getting paid for those services. The respondent's case guardian said, no, you provided those services out of kindness, and in lieu of getting payment, you resided in the respondent's residence. In this situation, the court determined and found that there was no de facto relationship. The next case I was going to talk about has a little bit of relevancy in terms of more new age relationships that now occur via the internet. So this case is Luck and Choi. There was found, so in that case, the parties had been communicating by early internet communications, and there was a promise of a de facto relationship in those communications, but it was not borne out after the relationship commenced. So the parties met on the internet. They both aspired to be in a long-term, meaningful personal relationship. They actually went to the step of buying a house together and stayed there and went on holidays there. They had an intimate relationship, but there was no public element to their relationship, and although they bought the house together, there was no intermingling of finances. So the respondent didn't introduce the applicant to his family, even though there was opportunity to do so. The applicant was more public about the relationship, but still didn't introduce the respondent to the applicant's family. And there was little intermingling of funds. So they both contributed an equal amount to the purchase of the property. When they did stay together, they both contributed equally to the expenses of those times and periods. In that situation, the court found that there was no de facto relationship. The next case I was going to talk about, and I apologise if you find these cases boring, but I think they do bring to light some of the more human elements that parties face, and when we have to give advice, what they're telling us their relationships were like, rather than the black and white letter of law. So this particular case is Benedict and Peake, and it's a 2014 Federal Circuit Court case. The background of this case is it was a 17-year relationship between 1992 and 2010. One child of that relationship was born in 1995. Throughout the claimed de facto relationship, Ms. Benedict received sole parenting benefits from Centrelink and declared to Centrelink in her income tax returns that her status was single. By the time of the trial, she had requested Centrelink to cease paying the benefits to her, but had given no explanation to Centrelink of the reason for her request and made no attempt to rectify the past misrepresentations. Miss Benedict had also admitted Mr. Peake's name from the birth certificate of the child born of them, unbeknownst to Mr. Peake, and failed to notify the child's school that Mr. Peake was the father of the child. The proceedings were commenced in February of 2011. Ms. Benedict applied to find that there was a de facto relationship and considered that she was in a de facto relationship with Mr. Peake. So she sought a declaration of that. Mr. Peake was denying that there was a de facto relationship. The issue in this particular matter and what it turned on for the court is in relation to the evidence of Ms. Benedict, and the evidence that was quite damning, that she had not declared the relationship and instead had communicated on multiple occasions that she was in fact single. and had received financial benefit for that. She had also admitted to include Mr. Peake on the birth certificate. Therefore, the court viewed that she had a cognizant intention to not be in a de facto relationship. She argued differently. She argued that she'd overlooked these, that it wasn't intentional, that it was just a circumstantial turn of events. The court then looked at when she communicated to Centrelink and stopped receiving the benefits, why she didn't seek to remedy the misrepresentation when she was aware of it, following on from her argument. Again, she gave no necessary answer to the court about that. What the court was asked to consider is, was there a de facto relationship? And if so, what was the length of the de facto relationship? And what was the finding? In this particular case, because of when the timing of the relationship was, remembering that they broke down in 2010 and the legislation didn't start until the 1st of March 2009, the de facto relationship could only be found for that period 1 March 2009 to 2010. But even then, on her own evidence, she denied the existence of a de facto relationship. So the court, in fact, found that there was no de facto relationship. Last case, which is Na and Tui. They love to pick difficult names to say in these cases. Again, I might do a poll for this one now that you've heard a few of the different cases. We all like to be the judge and put ourselves in the situation of the judge. So let me give you some facts about this one. It was common ground that the parties enjoyed a sexually intimate relationship for a number of years, which commenced in or about late 2005 and ended in early 2012. But they each perceived the relationship differently, which I'd say is not uncommon, and it's often something that we're faced with. The applicant felt that he and the respondent were a couple living together on a genuine domestic basis, whereas the respondent did not have the same degree of emotional investment in the relationship, and she rather considered that they were only boyfriend and girlfriend. The court was asked to determine on those facts of what their relationship was when they set out the details, whether they were in a de facto relationship or not, and whether, if they were in a de facto relationship, proceeding them with property and financial settlement. And I appreciate I've only given you some very brief facts, but to expand upon that, what the respondent looked at and why she said it was only boyfriend and girlfriend is that she maintained secrecy about their sexual relationship. She never communicated their relationship to her family or friends. The applicant did. In this situation, the respondent was also married, and she maintained her relationship with her husband, and she is in fact still married, and they have children together. They didn't, when they were sexually intimate, they were on holidays, so they would go and meet in places to have the intimacy in their relationship, and that occurred both in Australia and in China. And they were conducting themselves in a business sphere when they were doing it as well. So I'd love to get your thoughts as to whether you think this was going to be found to be a de facto relationship or not. Thank you for taking the time to vote. Like, it seems as if there's only 42% of you that have voted, so it would seem I'd say that there's a little bit of confusion out there, which is fine, because I think that is often the case for judges when they're trying to decide these matters. It turns on particular facts. Most of you have indicated that no, there wasn't a de facto relationship, and I'm glad to say that those that did, you are correct. There wasn't a de facto relationship found. So it's clear from the cases that they turn on their facts. It is important, therefore, us as professionals, when we're talking to clients, that we need to take detailed instructions, and particularly when we're talking to parties about whether there was or wasn't a de facto relationship, whether they're the party that's saying there was, or indeed the party saying that there wasn't a de facto relationship, we need to step out exactly what evidence there is to support either position that they're taking, and what the other party might be rely upon, and consider that evidence. So this will assist when we're trying to give them advice. It will assist in preparing any responses, and proceeding with any court action, so that we can avoid any surprises later down the track. I also think it is a timely reminder that we should not underestimate the importance of communications. Communications such as emails, cards, letters are good evidence to show whether there was a de facto relationship or not. It's not just limited to those declarations of love and commitment, but rather the emails and letters might show a degree of the daily living or the mundane matters as people we discuss, which show then a public aspect of the relationship. It might show a degree of mutual commitment to a relationship, or decisions that couples are contemplating when considering the continuation of their relationship. And that's really my cautionary note, is in determining whether there's a de facto relationship, when it started and when it ends, it's important to look at all the factors. No particular factor of those 8 that we discussed carries more weight than another, and I think the cases bear that out. And whilst the fact of cohabitation may appear at first glance to be that powerful indicator, the case law shows that it is not going to be the be all and end all, and there can be other factors that the court will give greater weight to. It's not all bad news. If there is a de facto relationship found and your client's the person that didn't want the de facto relation to be found, even if there is a de facto relationship found, the court will then need to look at property entitlements and whether there should be any adjustment. And there has been cases, and indeed the Chancellor and McCoy case that I have the citation for on the slide is such a case, where it found, notwithstanding that there was a de facto relationship, there was not the substantial contributions that there should be any adjustment of property interest. So in that situation, it was a same-sex relationship for about 20 years, and yet neither one received any adjustment of the other person's assets and liabilities. So it's not all bad news. I will give a plug to my colleague at this point to say she's doing a webinar. So Amy Ryan is presenting a webinar on the 4th of September of this year, which is the Back to Basics, the how of a property and financial settlement. So she'll certainly talk through in that webinar the elements that the court looks at in determining entitlements in property and financial settlements for both married and de facto couples. And that's really the next step upon the finding of there being a de facto couple. The other piece of advice that I'd pass out to clients, and certainly we can talk to with clients, is contracting out. So there is the option, if it is concerning for a client that they may be in a de facto relationship, and at this point they're in this de facto relationship, there is a way of contracting out of that, and the way of protecting themselves by entering into an agreement either at the start or during the de facto relationship that sets out how the property and financial assets and liabilities of the parties will be divided in the eventuality of separation. Now, that's a difficult conversation to have, and lawyers will assist parties in having those conversations, but it does take out the worry that a court might find an adverse, that there was a de facto relationship if you're denying it, or they might divide the assets and liabilities in a way that you don't necessarily want them to be divided. So contracting out is certainly something that clients can look at. You can do that agreement before or during, and essentially they're like a prenup, which is the colloquial term. So just to solidify my tips and traps, I think it's important for clients to make a list of questions for the lawyer, and whether that be advice on, am I in a de facto relationship, or if I'm in a de facto relationship, what should I do or how should I operate? Getting the specialist family law advice is key. You can see how the different factors and the evidence gathering and the minutiae detail in relation to establishing whether a relationship exists can affect a matter. A properly advocated matter can achieve a result that a poorly prepared matter may not be able to achieve. Every matter is very different, so please don't just accept because your neighbour went through something or the person down at the pub went through something that you can then take stock in what happened to them. And I think sometimes clients don't appreciate that it is a different set of certain facts for different people. Getting a plan, keeping focused on that plan, carefully considered process with your lawyer, whether you're doing the contracting out and you're going through that agreement, or whether you are looking at litigating a case or defending a litigated case. It's always important to get a plan and keep with that plan. So I did say at the start, if there were some questions, I don't think any's come through, but if there are questions now, I'd welcome those. To give you a little bit of background about what we could offer for your clients, we do a fixed fee, obligation-free initial appointment. That offers them the comfort of coming in. Usually that appointment is about an hour and a half to 2 hours. They know the cost of it, and we can usually answer most of their questions or give them a set of next steps for them to consider if they are going through court proceedings or contemplating what they are next going to do. No questions? Well, thank you again for giving me your time and attention, and I would love to have your feedback on the webinar and further topics that we can present to you on, because we certainly run out of ideas, so we'd love your feedback on that. Thank you.